Our next speaker, who I have the pleasure of introducing, is Mark Hartman. Mark works with the North York firm of Chaitin & Chaitin. He is a commercial litigator, and there is some emphasis in his practice in the area of mortgage remedies. Mark is also an instructor in the civil procedure section of the bar admission course. Mark was a member of the planning committee for this program, and I encourage you to listen attentively to his paper, which will deal with the sale of goods, another area where there's apt to be a proliferation of litigation now that we're in the down cycle of the economy. Mark Hartman.
Thank you, Barbara. This is not a topic which leads to the conversational talk that we experienced from Leon Perroyan and to the same extent from Joyce Harris. When during the development of this program I was asked to deal with the subject area, that is the measure of damages for breach of contract under the Sales of Goods Act, and it was primarily because no one else wanted to do it. I thought this is an area of the law where nothing much has happened for the last 50 years or so, and how am I going to make this interesting? Well, essentially I'm still of the same view, and I haven't answered the question. I approached the writing of this paper thinking that there wasn't too much by way of difference between the damages calculated under the Act and breach of contract cases generally, other than in law school and occasionally looking at the implied warranty sections of the Act, Section 15, that I would rely on the law of damages generally, and perhaps some people here are of the same view. As a result of the preparation of this paper, I came to learn that although to a large extent what I had as a preconception was true, and that the Act codifies the principles of law as they were in the late 19th century, the provisions of the Act which form the guideline for the measure of damages provide wrinkles which need to be reviewed in appropriate cases. It's important to note that the Act is not a complete code. Section 57(1) provides that the rules of common law continue to apply, and further, that the Act only has a presumptive effect. Section 53 provides that the contract itself can vary, modify, or exclude the rights and liabilities created by the Act. By way of general overview, Part 5 of the Act, which deals with and is entitled The Actions for Breach of Contract, contains most of the remedial provisions found in the statute. The right of action with which Part 5 begins is the seller's liquidated claim, as opposed to a claim for damages, against the buyer for the price of goods sold. It's simply the failure of the buyer to pay for the goods upon acceptance of those goods or upon delivery, and it's simply the contract price. Part 5 also preserves the common law rights of the parties to a sale contract to recover so-called special damages that are not included in the statutory measure of damages. The statutory rights of action and their accompanying remedies and damages are set out in sections 48, 49, and 51 of the Act. The rights and remedies in sections 48 and 49 concern the respective positions of the buyer on the one hand and the seller on the other, when a sale contract fails to be completed through the fault of one of the parties. Section 48 presents the seller's right of action against the buyer for non-acceptance of the goods, and Section 49 establishes the buyer's right of action against the seller for the non-delivery of goods. In contrast, Section 51 applies in situations where the sales contract has been completed despite the failure of one of the parties to fulfill its contractual obligation. In this case, Section 51 deals with the seller's failure to fulfill its contractual obligations. It is useful and instructive to examine the remedies set forth in the Act in the context of the general principles more extensively covered in some of the other papers that we've heard today, particularly Justice Morton and perhaps Professor Wadhams. I don't propose to reiterate them, and Hadley and Baxendale is the general law that would apply as I said, in a general way. It is submitted the Act presumes no recoverable consequential losses will arise in the great majority of cases because of appropriate mitigation of losses should prevent the occurrence of consequential damages. The statutory presumption that mitigation of loss follows a breach of contract can be illustrated by the Prima Facie tests, which are adopted in the sections I've referred to, 48, 49, and 51. The Prima Facie test for calculating damages flowing from a seller's non-delivery of goods or the buyer's non-acceptance of the goods apply only where an available market exists. It's important to remember that term. Where this condition is satisfied, the court may quantify damages by calculating the difference between the contract price and the market or current price. The underlying assumption concerning the mitigation of losses may be less significant in claims for damages for breach of warranty, which is the Section 51 cause of action, than in claims for non-delivery and non-acceptance, but it continues to play a role. The Prima Facie test in Section 51 is a little bit different and applies only to breaches of a seller's warranty as to quality and measures the difference in value between the promised goods and the defective goods actually delivered at the date of delivery. This Prima Facie test clearly has certain intrinsic limitations. A seller's breach of warranty in a completed transaction may not be as readily discoverable on the completion date as would a failure to complete the transaction through non-delivery or non-acceptance. The time or times for measuring losses are important components of the Prima Facie test set forth in the Act. The mitigation rules also require an innocent party to a broken contract to act promptly, as you would expect in the normal mitigation scenario, to reduce avoidable losses. The innocent party is not allowed to play the market at the contract breaker's expense by delaying re-entry in the hope of obtaining a more favorable price. If the aggrieved party chooses to speculate on market prices, it must bear the risk of any additional losses caused by that delay. The three Prima Facie tests simply proceed on the assumption that the innocent party at the stipulated time proceeded to mitigate its losses. For purposes of these tests, the actual behavior of the innocent party on the relevant date or dates does not matter. Although not explicitly stated in sections 48 and 49 and 51, the sections do embody the basic principles of measuring damages in contract law, that is, the protection of expectation interests, the mitigation of losses, and remoteness limitations. Section 47 of the Act that I referred to briefly before deals with the seller's remedy being the price of goods sold where title is passed, subject to the exception under subsection 2 of Section 47. Almost always where you're in a situation where you've sold goods and the goods have been accepted and have been delivered, you will sue under Section 47 for the price of the goods. The damages are easily calculable, of course. There's no remoteness or mitigation problem, and it's quite an easy case to prove. The problem may occur in this situation where the seller misconstrues the situation and either holds on to the goods or sells them right away when the situation would have called for the reverse. And accordingly, your client may be penalized in damages. So it's important to assess what the situation is and the factual foundation for the claim that you're making. Dealing now with action for damages for non-acceptance of goods, this is Section 48, sub 3. And in parts 48 to sub 3, on page 11 of the paper, it's quoted, where there is an available market for the goods in question, the measure of damages is prima facie to be ascertained by the difference between the contract price and the market or current price at the time or times when the goods ought to have been accepted, or if no time was fixed for acceptance, and at the time of the refusal to accept. This is a test of first appearance, and it only applies in circumstances where an available market exists for the goods in question. Therefore, its application by the courts is rather discretionary. Available market has been defined, at least in one case, and it's the case is cited in the paper, as merely means that the available market merely means that the situation in the particular trade in the particular area was such that the particular goods could freely be sold, and that there was a demand sufficient to absorb readily all the goods that were thrust on it, so that if a purchaser defaulted, the goods in questions could readily be disposed of. And that basically takes into account the law of supply and demand, a basic economic concept, and was an advance from the laws that stood in the late 19th century. Dealing with the phrase available market, an aggrieved party is expected to promptly mitigate the loss, but is not required to make extraordinary efforts in order to minimize the flow of losses. The aggrieved seller must behave reasonably in efforts to dispose of the goods, but is not under an obligation to do anything otherwise than in the ordinary course of business. In the absence of an available market, the innocent seller reasonably could take other steps such as sale by auction or sale as scrap in order to mitigate its losses by disposing of the goods. One sometimes overlooked issue has been the loss volume problem, which involves a situation where the supply of a commodity exceeds the demand for that commodity. And the issue has arisen most often in the sale of motor vehicles, at least those are the cases where the issue tends to come up, where if the Prima Facie test was applied, the seller would be entitled to at most nominal damages because, as we know, the price of motor vehicles doesn't change very much, at least it's controlled pretty strictly, at least in our market today. In those cases where supply exceeds demand, the courts have excluded the application of the Prima Facie test and allowed the seller to recover the lost profit from one additional sale when it sells the rejected goods to a substitute buyer who otherwise would have purchased other goods from the seller. An exception to this line of cases is the unique or custom-made good where this would be the only sale. The discussion of that is much more detailed in the paper, of course. The buyer's remedy, under Section 49, tracks virtually the same language as in Section 48, being basically the mirror image of Section 48. There may be some confusion which exists between the interpretation of Section 48 and Section 51. And an action for non-delivery under Section 49 is what it says. Late delivery claims do not find shelter beneath this provision because late delivery is not non-delivery. Unless the late delivery occurs pursuant to a contract where time is of the essence, so that late delivery becomes non-delivery under the agreement. Losses caused by late delivery under sale contracts lacking essentiality of time clauses would be recoverable in the Section 51 action for breach of warranty. With respect to non-delivery, under the Prima Facie test with its adoption of the market price for the substituted good, the actual price paid by the buyer to replace undelivered goods may have evidentiary value to support the finding of a market price, but will not in itself override a normal determination of the market price. A buyer who strikes a bad bargain by paying a price unreasonably higher than the existing market price will not be permitted to burden the seller with the excessive portion of that price. Nor will a buyer who is able to obtain substituted goods for less than the market price be confined to a measure of damages based on the lower actual price rather than on the market price. The market price test prevents the seller from exploiting the buyer's unusual skill in the market and protects the seller from the buyer's unjustified extravagances. Similarly, a buyer that defers unreasonably the return to the market for replacement goods takes upon itself the risk of changes in the market price. The Prima Facie test, or market price contract price differential, is efficient in that it estimates an easily calculable it establishes an easily calculable formula whereby damages can be determined. A good illustration of how this Prima Facie test works is in the William Brothers and Ed T. Angus Limited case, which is set forth in the paper, and I urge you to read that portion of the paper. What about the situation where there is no available market? The buyer, in my view, must still make efforts to mitigate. However, the measure of damages is Section 49 sub 2. That is, the general consequential damages set forth in the first branch of Hadley and Baxendale, and not 49.3 with its market price contract price differential. The issue of substituted goods of a superior quality is dealt with in the paper. An effort to mitigate the buyer would be well advised to listen to settlement overtures of the seller, although they're not bound to deal exclusively with the seller on the basis of non-delivery or non-acceptance. It's always a good idea to see whether or not a new deal can be structured for the delivery of the goods. Also outside the prima facie tests is a situation where either the buyer has itself entered into a resale contract for the specific goods bought or agreed to complete a sale immediately following the purchase from the original seller and has no replacement goods on hand. In these situations, consequential losses almost certainly flow. However, unless the seller knows of the resale of the goods at the time it entered into the original contract with the buyer would not be compensated for these losses. Now, dealing with late delivery, which, as I've indicated, is a Section 51 problem. While goods in the hand of a buyer, while with the goods in hand, the buyer has obtained the expected benefit of the seller's contractual performance, except for losses occasioned by the delay in delivery. Thus, the prima facie test for the measure of damages would not be the difference between the contract and market price, but rather the difference between the market prices on the breach date and the actual delivery date. However, there is no prima facie test for breaches of warranty other than breaches of warranty of quality. As the prima facie test in Section 51, sub 3 of the Act applies only to breaches of warranty of quality, direct damages for late delivery, the Hadley-Baxendale scenario, will fall within the scope of the general rule for all breaches of warranty in Section 51.2. The measure of damages for breach of warranty is estimated losses directly and naturally resulting in an ordinary course of events from the breach of warranty. This, of course, is the familiar first branch of Hadley, as I've indicated, and in the sense of buyer seeking damages for late delivery of goods has no need to look at the Act at all. Late delivery may also lead to other consequential losses which are compensable. For example, the buyer, to the knowledge of the seller, holds goods for resale, and I've discussed that briefly. The seller may be liable for the buyer's compensation payments and legal costs to the purchaser from him on resale, unnecessary costs as a result of the delay, i.e. overtime wages and other cleanup or other remedial costs which may be required to be paid. Dealing now with the breach of warranty of quality. Goods that do not conform to the description or standard established by the sale contract can be rejected by the buyer in an action claiming damage for non-delivery commenced under Section 49. In such situations, buyers can look to Section 51 for at least part of the relief they are seeking for losses which flow from delivery of defective or damaged goods. The Act defines warranty to mean an agreement with reference to goods that are the subject of a contract of sale, but collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages but not to a right to reject the goods and treat the contract as repudiated. The remedial provision contained in Section 51 also applies to breaches both of the statutory conditions and warranties and of express undertakings given pursuant to a particular sale contract. Typically, however, buyers will take delivery of non-conforming goods without the knowledge that they do not conform, and this creates certain problems. The goods may have been acquired and resold or installed or in other goods without the buyer becoming immediately aware of the defects. Repairs or replacements may be made only after a considerable lapse of time, and moreover, the prima facie test applies only to breaches of warranty of quality, as I've said. This presumably would include all warranties pertaining to the state of or condition of the goods, while excluding breaches of warranty such as late delivery. The damages are calculated as the expected value of the goods to the buyer on the delivery date, less their actual value to the buyer on that date. The prima facie test in Section 51, sub 3, relates to a breach of warranty and provides, as I've indicated, the damages be calculated as the expected value, rather on the delivery date as opposed to, less their actual value to the buyer on that date. Let's deal now with the problematic area briefly, the problematic area of loss of profit. Joyce Harris dealt briefly with that, and she talked about the Primo case and the Palmolive case and the Klein & Vickers case. And as she's indicated, the courts have been extremely cautious in permitting recovery of lost profits on a revenue-generating good in order to avoid what in their view might be double recovery for capital and income loss. That is, the courts have recognized that in order to obtain profits, the buyer would have had to make the capital investment for which it is seeking recovery. If the buyer sues to recover lost profits, some courts have held that it must choose one or the other. That is, it cannot recover both its lost profits and its lost capital. I would submit that the courts, when dealing with these problems, must keep in mind what has been recognized in several cases, which is that in many commercial contract disputes, the plaintiff, had the contract been completed, would have enjoyed at some point in time after performance, one, a return of net profits generated by the income-earning asset during the relevant period, as well as, two, a depreciated conforming asset. Unless the lost profits are awarded over the full expected life of the investment or to the point of mitigation, the buyer may very well be undercompensated. In these cases, the buyer should be awarded the difference between the actual value of the investment and the value of the investment had the contract been performed, and loss of profits incurred before the buyer, acting reasonably, could have mitigated losses by purchasing an alternative machine. If I can offer any practical advice, it would be this. Don't get lost in the technical rules, although this discussion today has been and nothing but. The starting point must be the assessment of two positions. One, the actual contract breach position and the hypothetical contract performance position. A dollar figure must be put on the plaintiff's damage claim. Once you've done that, then you can worry about the technical rules. And once you've worried about the technical rules, you must also take into account wasted or additional expenses incurred, including those expenses on resale, mitigation expenses, pre-contract expenses, loss of income from the profit-generating capital assets, loss of profits on sub-sales, liabilities to sub-buyers, costs paid to sub-buyers, settlements, etc. Finally, once you've done all that, apply the limiting principles of remoteness and mitigation, which may disentitle the plaintiff to the recovery of some of these losses. Thank you.
Our last speaker this afternoon is Alan Rock. He probably needs no introduction. He's known to you all, I'm sure, for his role as a bencher. Chairs two important committees of the Law Society. He's also the head of the Civil Procedure section of the Bar Admission Course. For those of you who've had the pleasure, as I have, of having Alan as an opponent, you know him to be a formidable opponent and one who has the knack of making the complex seem simple. Alan's topic, as set out in the schedule, is tortious interference with economic relations. He, in fact, is limiting his paper and his remark to one type of tortious interference, that is a creditor who interferes entirely with the debtor's economic relations by putting an end to them, by destroying the debtor's business. Alan?
Thank you very much, Barbara. She only says those kind things because every time we litigate, she wins for some reason. I don't understand that. It's true that my paper and indeed my remarks today are not as advertised, which I suppose it could expose me, Mark, to some action for breach of warranty, express or implied. But it seems to me that, I take the pessimistic view of the current economic circumstances, and I believe that before this is over, the vast majority of us are going to be practicing insolvency-related litigation. So we might as well deal with this topic in that context. And when a secured creditor marches into a debtor's business on the basis of the security and seizes it, liquidates it, in effect destroys the business, and is subsequently found to have acted tortiously in having done that. And the challenge that you and I face as counsel is a very complex one, to establish for the court the basis on which the damages arising from that misconduct should be calculated. Whether you're for the plaintiff or defendant, the issues are complex, and the challenge for counsel to present clear and complete evidence on the issues that arise is significant. An analysis of this area must begin, although not necessarily end, with the thorough and characteristically lucid judgment of Mr. Justice Morden for the Court of Appeal in Lister and Dunlop on the damages question. We are indebted to Mr. Lister for lending his name to two leading judgments in this area, not only the initial one in 1982, having a reference to the question of liability, but also to the 1985 judgment of our Court of Appeal on the question of damages. By the way, Mr. Lister also demonstrates the kind of patience and tenacity that's needed by a plaintiff in this kind of litigation. Just consider this chronology. The original seizure about which he complained occurred on March 20th, 1972. He commenced his action for damages in January of 1973. He then went to a trial before Mr. Justice Rutherford, who directed a reference. The judgment of Mr. Justice Rutherford was appealed and overturned by the Court of Appeal. That went to the Supreme Court of Canada, which decided the issue in 1982. The reference then went back before Master McBride, who reported in 1984 to Mr. Justice Rutherford, and that judgment was appealed and the matter resolved by the Court of Appeal in 1985. Counsel tell me no application was brought for leave to the Supreme Court of Canada, but the final judgment emerged some 13 years after the initial seizure. So if in these hard times litigation counsel are looking for a source of secure and long-term income, you might consider acting in actions of this kind. Probably safer to act for the bank defending, but Mr. Lister did all right. Now, I don't propose to deal with the question of liability in cases of this kind. The paper deals briefly with the principles governing that issue. I'm going to confine myself today to the issue of damages, and as between the two of them, compensatory and exemplary, deal just with compensatory, and I commend to you Scott Turton's excellent paper for a treatment of the exemplary damage award. So far as compensatory damages are concerned, for the debtor, when a secured creditor marches in and takes over the business, the question boils down in its simplest terms to this: what has the plaintiff lost? Because conversion, which is the favored cause of action in these circumstances, is an intentional tort, the Court of Appeal has held that the proper legal principle on which to proceed is that only those damages can be recovered that flow as a direct result of the tort. So on the facts, what did the debtor lose? The threshold question is whether the business now destroyed was viable on the date that the creditor entered. In other words, had the creditor given reasonable notice or behaved responsibly? Could the debtor have come up with the money, paid off the debt, refinanced, carried the new loan out of the net proceeds of the operating business? In that sense, was the business viable on the date of the alleged wrongdoing? Now, that's a question of fact in each case. In Lister and Dunlop, the court held that it was a viable enterprise, and they relied upon the fact that even before the event, Mr. Lister was negotiating with another company to become his franchisor because the initial relationship with Dunlop was not succeeding. In Mr. Broadloom, another case referred to in my paper, Master Linton on the reference accepted the evidence of the principal of that company that he would indeed have been able to obtain new financing to retire the debt and would have had a sufficient income flow to service that new debt and make the business succeed. The master noted that the principal was not cross-examined on that point, and that the defendant called no evidence to the contrary. And although the evidence of the principal could be regarded as self-serving to some extent, it was really the only evidence on the point. The master accepted it. This initial issue of viability, could the business have survived if reasonable notice had been given, is crucial because if the court finds that it was not viable, as, for example, Mr. Justice Hollingworth did in the Cavcar case, then the successful debtor, even though the cause of action is established, is limited to recovering the liquidation value of what was there. In other words, if the assets had been sold off piecemeal in an orderly fashion, how much would have been realized as opposed to how much the secured creditor realized when the creditor barged in. But if the business is held to have been viable at the relevant time, then the debtor or plaintiff who establishes liability is entitled to the higher of the going concern value of the business at that time or the net asset value. And going concern value is almost always the higher valuation. Now, I propose to deal briefly this afternoon with the approaches that the court has taken to the assessment of damages of a business as a going concern. And at least two major theories have evolved in recent years. Most of them, I think, should be attributed to Doug Stewart. Mostly they're his responsibility. He was counsel in the cases of Mr. Broadloom and indeed in the damage appeal in Lister and Dunlop. So his creativity in devising these approaches to damages is probably very much the reason why we have the analysis we do in the cases that I refer to. Now, the two theories that I speak of are, first of all, just generally, if I may refer to it as, a multiple of estimated future income. And the second is the discounted cash flow theory. And let me deal briefly with each of them, just to give some flavor of the kind of approach the court takes in each. First, the multiple of estimated future income. This was the approach taken by the Court of Appeal in Lister and Dunlop. And it addresses these questions in relation to the viable business that's destroyed. First of all, what would the future revenue of the business had been had it been permitted to continue? Secondly, over what future period should we assess the lost revenue? Thirdly, what rate of return should we assume in calculating the entitlement of the successful plaintiff? Thirdly, what method should be used to capitalize the loss? What about taxes, contingencies, future risk? A brief review of the facts of Lister. You probably remember them. He was the franchisor of the tire business, operating at a loss, signed a debenture to secure the indebtedness to Dunlop for $175,000. $127,000 was outstanding. In that day in May of 1972, Dunlop both demanded the amount owing and put in the receiver simultaneously. That gave rise to the liability for not having given reasonable notice. Now, Mr. Justice Morden in the Court of Appeal on the damage question in the 1985 judgment accepted the master's finding on the reference that the business had a future, assuming that Mr. Lister, had the money been demanded with reasonable notice by Dunlop, would have made other arrangements with Goodrich, found another franchisor, and continued on successfully. Very significantly, the only expert evidence before the master on the reference, and therefore in the record before the Court of Appeal, was the testimony of Colin Loudon, called as a witness for the defense, Mr. Loudon of Pete Marwick, who testified that in his opinion there was no future potential for profit at all in the Lister business. Now, the master rejected that conclusion, but he also rejected all of the testimony of Mr. Loudon with respect to accountant's methodology in valuing businesses as a going concern. And the Court of Appeal held that he was wrong in doing that. It was the only expert testimony before the master. The master ought not to have rejected the principles without good reason for doing so. And indeed, the master, so said the Court of Appeal, proceeded upon erroneous and arbitrary principles in coming to his assessment. The important passage of Mr. Justice Morden's judgment at page 107 of the report: while the calculation of damages for future loss, his lordship said, is not an exact science, and inevitably must involve some steps that can be called arbitrary, there are degrees of arbitrariness. The master, for example, had said, I'm going to calculate Lister's loss, assuming that it would have been in business for 30 more years. Well, Mr. Justice Morden said, why 30? Why not 15 or 45? Where do you draw the line? Mr. Justice Morden found that the master had erred in approaching this question from the wrong end. It wasn't like assessing the damages that someone suffers in a motor vehicle accident when there are personal injuries, or where there's a fatality, and you try to determine what the person would have earned over the balance of that person's life. It isn't that kind of case. Here you're dealing with a business which, if found to be viable, has a present value and is quite capable of going on and earning future profit. And the question is a business one. What is the present value of that as a saleable asset today? Not some present quantification of potential future profits to the end of its business life. So his lordship went to the evidence of Mr. Loudon, which, as I say, was the only expert testimony on the record, and he adverted to those principles in articulating the formula that he ultimately identified as the appropriate one in cases of this kind. Mr. Justice Morden adopted as the appropriate basis for determining value as a going concern the capitalization of future anticipated income. And that involves the following steps. First of all, you estimate what maintainable income level can be achieved by this successful business after tax. And second, you capitalize that income at a rate of return that an investor would consider appropriate for this kind of business. Now, what does this mean for the likes of you and me as counsel who might have to go in front of a judge and try to prove damages on this kind of formula? Well, it seems to me that, assuming that there are degrees of arbitrariness, as Mr. Justice Morden says, our challenge will be to marshal the facts, including expert opinion, to answer the following, or at least the following questions for the court. First of all, is the business viable? Was it viable on the day that the creditor came in? I've spoken about that. That's a question of fact. And you'll have to get the testimony of the people in the business, look at the economic track record, perhaps call witnesses who carry on similar businesses in that industry, in that economy of that time, to persuade the court that, as a matter of fact, it could have gone on and succeeded. There were alternative sources of financing, that the financiers would have been prepared to advance their money, and the new debt could have been carried from the income to be generated by the continuing business. Secondly, how much revenue would the new business have generated had it remained in the marketplace? What was the level of income that was maintainable based on that revenue? What rate of net return would have been generated for this business in that economy? And what profit would reasonably have been expected by an investor in this kind of business? Now, you'd think you'd have to have a crystal ball along with all the rest of the material on your desk when you're assembling your damage claim. There is an element of arbitrariness in all of this. But a reading of these cases discloses, at least to me, that the court, recognizing that there's some guesswork involved, will canvass the record for the most reasonable expert's approach to those questions, and then do the best it can in an admixture of an accounting exercise on the one hand and a calculation of damages in tort to redress harm done to an aggrieved party on the other. For example, as to the last question I put, what rate of net return would be generated, what profit would reasonably be expected by an investor in this kind of business, Mr. Justice Morden looked at the economy of the day, 1972, when the tort occurred, and said, well, what were Canada savings bonds paying in those days? As a matter of fact, they were paying between 6 and 7%. Having regard to the kind of risks in a tire business, what would an investor want as a return on money to hazard it in that kind of enterprise rather than in a blue chip, guaranteed 6 or 7% Canada savings bond? And his lordship concluded that an investor would want between 10 and 12%. It would be higher than that, the more speculative the business that the court is dealing with. Perhaps lower, the more reliable the business. And then the question of the multiplier, the rule of thumb to determine the multiple of net income for which you'd expect the business to sell. The multiplier is determined, said the accountant, and Mr. Justice Morden accepted this, by dividing 100 by the capitalization rate. That is, the capitalization rate and the multiplier have an inverse relationship. The higher the capitalization rate, the lower the multiplier. In Lister, The capitalization rate, as I said, was 10 to 12%, and that translated into a multiplier of between 10 and 8.3, in that range. Now, applying that formula to the facts, Mr. Justice Morden accepted the master's finding that the new business would have had an annual gross revenue of $500,000. 10% of that for net income would be $50,000. And then there had to be contingencies considered. You can't simply assume that the net income of $50,000 a year would be invariable. There are risks attendant in any business. There's competition. There's sometimes difficulty entering the marketplace. And there's a general economic climate, which can be a significant influence. Taking all those risks, those contingencies into account, Mr. Justice Morden reduced the $50,000 per year net income predicted by some 45%, less than the 50% the master had reduced it by, since the master had improperly considered the state of Mr. Lister's health as a variable on the risk assessment. Mr. Justice Morden pointed out quite sensibly that that's irrelevant to someone who's going to buy the business and take it from his hands. So the $50,000 a year went down by 45%, it became $27,500. Deducting income tax, because you have to take it net of that, at a rate of 25% left you with about $20,000 in hand. And then you apply the multiplier of between 8.3 and 10 to that net amount to quantify in present terms future earnings that a purchaser in the marketplace would be prepared to spend to buy the business. His Lordship used 10 instead of 8.3 to give the benefit of the doubt to the innocent party, the debtor, and arrived at a global figure of $206,000. But that didn't end the matter, because the business had to be valued for a purchaser who would take it debt-free. So from the $206,000 that was the capitalized present value of projected future income, His Lordship deducted the amount of debt still owing to Dunlop. Now, some of it had been repaid by Dunlop to itself when it sold off the assets that were seized, some $88,000, I believe. So he took off the balance of debt still owing to Dunlop, and he came up with the new subtotal of $165,000. Had there been any assets in the business that were surplus or redundant, in other words, capital assets that were on hand but not being used to earn income, those would have been separately valued, and their value would have been added to the award to the debtor. There weren't any in this case. All the assets, all the current assets on hand were being used to generate income. His Lordship pointed out that the master had been in error by awarding double recovery for not only giving an amount that represented lost future income as presently valued, but also as a separate and additional amount, the value of capital assets on hand. His Lordship said, wait a minute, you've already counted that in the first time round, because the value of the assets producing the income is part of the going concern value of the business. And if you give the going concern value plus the separate asset value separately, unless they're redundant and surplus and are sitting around being unused and are valuable assets in and of themselves separately, you shouldn't value them in addition. And then one last adjustment after coming out to the new subtotal. His Lordship accepted Earl Cherniak's argument that you shouldn't start from today and go forward assuming an unbroken stream of profitable years. You should assume that if Mr. Lister is going to go into this new enterprise with his new franchisor, there's going to be a period during which he has to work to hit his stride. Earl Cherniak argued 2 years should be reduced because it would take them that long to earn the kind of profit that's assumed in the valuation of the future potential. His Lordship said, that's a good point, but 2 years is too much. I'll give you 1 year. We'll lop that off. And he did. Again, rough justice, a degree of arbitrariness, but always, it seems to me, a rational basis for the step that's taken. Now, after all of that was done, His Lordship looked to the net asset value. Remember, I said at the outset that if the business is viable, the successful debtor who establishes liability is entitled to the higher of the value of the business as a going concern or net asset value. And going concern will usually be higher. Well, His Lordship valued the assets and found that they came to an amount slightly less than the going concern value, and so felt that the court was warranted in awarding the higher amount. But indeed, the comparison would have been even more dramatic. if you take into account the fact, as His Lordship mentioned, that from the net asset value, you also had to deduct the amount still owing to Dunlop from the debt that was not yet fully repaid. So, to the earlier list of variables that I mentioned, when speaking of the challenge that we as counsel face in marshalling our evidence in this kind of action, add these that arise from the principles I've just touched upon. We'll have to grapple with the evidence about contingencies and risk in the business that we're dealing with, the question whether there are surplus assets or whether they're all being used to generate the income, the question whether it's appropriate to reduce the award for the initial period needed for the business to hit its stride when it starts again after the seizure, and finally, the valuation of the assets. What would they fetch in an orderly disposition by a responsible and prudent creditor? Now, in each of these issues, we're going to have to find credible and attractive evidence to establish or undermine the propositions, depending which side we act for. Let me touch briefly upon the second method, the discounted cash flow approach, and then I'll stop. You've had a long day. Mr. Broadloom, another one of Stewart's cases, is an example of that theory in action. Again, consider the years involved here. The seizure occurred in April of 77. The action was commenced by the debtor. Mr. Justice Linden dismissed it in 79. Court of Appeal allowed the appeal in 83. They waited to see what was going to happen in Lister and Dunlop. The master conducted the reference in 1987, and then Mr. Justice Hughes, on an appeal from the master's disposition on the reference, allowed the appeal and directed it back to the master for a fresh reference. An appeal was taken to the Court of Appeal from that disposition, and that was settled in 1988, 11 years after the initial seizure. But Master Linton, in his judgment, which is reported as referred to in the paper in the reference in 1987, adopted the evidence of Laventhal and Horvath for the plaintiff debtor that the proper method of valuing the business on the facts of that case was to estimate a cash flow stream that the company would generate in the future beyond the date of the seizure and discount it to its present value. Now, that's not consistent with Mr. Justice Morden's approach in the Court of Appeal, but bear in mind that in the Lister and Dunlop case, the only evidence on the record was that of Colin Loudon, and the only theory that he identified was the valuation based on future projected stable income. So he didn't rule out other approaches to valuation. He made it clear it was a business matter and not like assessing damages for personal injury. And he made it clear also that these cases can, based on their facts, attract different appropriate methods of valuation. So Master Linton determined that the discounted cash flow was appropriate. And I'll just spend a few moments mentioning that in applying that theory of valuation, the master determined the appropriate number of years over which to value the cash flow. In this case, Laventhal and Horvath said 7 years, and he accepted that. Estimated the net income each year, discounted that net income each year back to the value of the money on the date of the tort, and then discounted based on risk and contingencies, added up the 7 years net discounted cash flow totals, and came to a grand total. Now, to that he also added the value of the business as a going concern after the 7 years, because even after the 7 years you'd have what he called the residual value, and then discounted that figure as well back to the value of money on the date of the tort. That produced a lower amount than what would have been arrived at using the Lister and Dunlop future earnings ratio approach that Mr. Justice Morden identified. There were a number of issues arising from Master Linton's judgment on the reference in Mr. Broadloom. Can hindsight be properly used in determining the risk and contingency factors of the discount? The defendant said, no, you can't use hindsight. You must approach it in a clinical and theoretical method. The argument to the contrary is, well, you're trying to do your best to put the plaintiff back in the position he would have been in but for the wrongdoing. Why don't you advert to reality in doing that? Surely that'll be the best reference to what happened in the intervening period. Why can't we use it? There was also controversy about the appropriate amount for discounted contingency and about the basis for assessing the value of inventory. Should it be cost or should it be retail value? If you have a business which had a warehouse full of widgets ready to go to the market, selling well, each able to fetch $20 as the retail value, why value them at $8, which is cost? Does that reflect the true loss of the debtor who's been hard done by? Master Linton said cost. That issue's still a live one, it seems to me. Now, all of these questions were going to be answered, but as I say, the appeal was settled, and we're going to have to wait till some other litigation comes along for the questions to be clarified. I commend the paper to you. As I say, I think that the whole subject's going to be of continuing interest in the days to come, not only because of the economy, but also because the amounts in cases of this kind are significant, and there are important aspects of the issues as to entitlement and quantum that still remain unresolved. I hope you find the paper of use, and I thank you for your attention.
Thank you all for coming. One last reminder to fill out your evaluation forms.